What we discuss in this podcast is general information only and is not legal advice. Also, our discussion does not give rise to a solicitor-client relationship between us and you, our listeners. If you are currently facing any issue or problem, you must obtain your own independent legal advice. Some law firms provide a non-obligatory, free-of-charge first meeting, especially for divorce and criminal matters. All opinions expressed here are our own. They do not reflect the values, opinions, and practices of our firms, friends, and families.
Okay, so today we'll be talking about the case of Tan Yu Sin. For those who are unfamiliar with the case, Tan Yu Sin was a Grab driver who was accused of sexually assaulting his 19-year-old passenger. He himself, he was 48 years old, he was married with 3 kids, just for some background. So his decision was recently reported in the newspaper. I think the newspaper was published 28th of April 2022, so very, very recent from the date we're recording this episode. So we want to talk a little bit about the decision that was made. So let's start with the fact scenario. What happened in this case?
Well, in terms of the facts, unfortunately, whatever we have to glean from the newspaper reports. This is because the judge has only just released oral verdict with some brief reasons. He hasn't set out his reasons in writing yet. So what has been reported in newspapers were what had been picked up from the judge's oral verdict. And essentially, the Grab driver was acquitted of rape. And the reason he was acquitted of rape was the judge found the passenger had consented to sexual acts, or if the judge was wrong in finding that the girl had consented, the judge would have accepted the accuser's defense that he had mistaken that the girl was consenting.
Okay, so I think he was charged with 3 charges, but the charges were not exactly rape. They were attempted rape, sexual assault, and outrage of modesty. So he wasn't actually accused of rape, he was accused of attempted rape. Okay.
Yes.
Whenever we talk about rape, we talk about the idea of consent.
Yes. So consent, or rather to be clearer, lack of consent is an ingredient of each of these sexual offences. So just now C correctly pointed out that 3 charges have been preferred against this accused person. Number 1 is attempted rape. Number 2 is sexual assault involving penetration. That means that there was some sexual penetration of the complainant other than with your sexual organ, because if it's with your sexual organ, obviously that would be rape. So we have that. And we have outrage of modesty. Outrage of modesty is what we know as molest. And running through all these 3 offences is an ingredient that the prosecution must prove beyond a reasonable doubt, lack of consent from the complainant.
So one of the things that is very interesting in the law relating to consent and rape is the question of whether somebody has the capacity to consent. When we talk about capacity, the reason why this question arose in the first place is because a lot of these acts occur perhaps after a night of partying, perhaps after use of drugs or consumption of alcohol. And so there have been a lot of victims who have said that they were drunk and therefore had no capacity to consent. So there is a question as to what is capacity to consent and how do we determine whether somebody has the capacity to consent.
So the principles regarding the specific issue of whether you can consent even while under the influence of alcohol, it is actually quite a well-established legal test. It has been really previously set out. So this judge wasn't applying any new law. We had a 2016 Court of Appeal case, and the Court of Appeal says that the main issue is not whether you are intoxicated or you are not intoxicated by the alcohol, because just because you are intoxicated doesn't mean that you don't have capacity to do things purposefully, or you don't have capacity to make important decisions. The important test really is, do you have sufficient ability to really know what you are doing? And as you can tell, it is quite a broad brush, vague test, and the reason for this is that so many of these things are based on the facts of each case.
We actually took this test from an English case previously decided. So the English case was stated in a 2016 Court of Appeal case that Jiu was talking about. And I thought it was a very nice summation of what the test is. So I'll just repeat it because it was very well written. It basically says, consent on the part of a woman as a defense to an allegation of rape requires voluntary participation, not only after the exercise of intelligence based on the knowledge of the significance and the moral quality of the act, but after having freely exercised a choice between resistance and assent. A woman is said to consent only when she freely agrees to submit herself, while in the free and unconstrained possession of her physical and moral power to act in a power she wanted. Consent implies the exercise of free and untrammeled right to forbid or withhold what is being consented to. It is always a voluntary and conscious acceptance of what is proposed to be done by another and concurred in by the former. The question really is, how do we determine this? Where does the threshold lie? And this same English case, they said something that I think is even more compelling, which is that a person can have the capacity to make a choice and have sex even when they have had a considerable amount to drink. Consumption of alcohol and drugs may cause someone to become disinhibited and behave differently from the way that they would normally behave. But if they are aware of what is happening, then the consumption of alcohol or drugs has caused them to consent to the activity which they would ordinarily refuse. They still have consented, no matter how much they regret it later. The fact that a person makes an unwise choice does not mean that he lacked the capacity to make it. A drunken consent is still a consent, if a person has the capacity to make the decision whether to agree by choice. So let's bring this principle, this test, back to the current situation now. So in the current situation, Justice Pang, the judge that made this decision, he determined that actually the 19-year-old girl, she had capacity to consent, and she had consented to such acts. T, you want to tell us why the judge decided that the 19-year-old girl had capacity to consent in this instance?
So the first point is that the victim had demonstrated a capacity to understand and decide at several points during the night, such as by repeatedly rejecting her friend's offer at the bar to drive her home. So that rejection on the part of the victim was one of the factors that showed that she still was able to perform her cognitive functions and was able to understand and decide on certain matters. So that's the first one. In addition to that, the victim had also told the accused when they got to her condominium complex that she was not ready to leave the car and search for money to pay for the ride. So this also demonstrates the ability to think, the ability to decide. Right at the end of the sexual acts, when she began saying no to the accused and pushed the accuser's hands away, this conveyed an intention that she did not want to be touched and that she was aware of what was happening. After the sexual encounters, the victim had told the accused that she was okay and asked him to drive, and according to the judge, this showed an ability to assess whether to leave or remain in the car with him. So, having reviewed the evidence and all of these facts, the judge found that she had the ability to understand and to decide, and that she had control over her cognitive functions.
So we've talked about a situation where essentially somebody was drunk, but the judge found that despite being drunk, she still had the ability to consent. Can we contrast this with an example of when the victim was drunk and the judge found that she had no ability to consent? Because ultimately, this is a very fact-specific question, and the answer would change depending on specific fact scenarios that occur. So in this case, the judge found that she had the ability to decide for herself. We'll move on to another case where the judge found that she did not have an ability to decide for herself whether or not she wanted to consent to such sexual acts. So G, you were talking about the 2016 case. I think the 2016 case is where the court decided that she literally had no ability to consent to the sexual acts. You want to bring us through that case?
So, in this case, the Court of Appeal actually made it quite clear that to no longer have capacity to consent, there is no need for the victim to have become completely unconscious. You can lose your capacity to consent even before you become unconscious. So what the Court of Appeal said is a complainant who is unconscious obviously has no capacity to consent, but a complainant may have crossed the line into incapacity well before becoming unconscious. And whether that is the case is evidently a fact-sensitive inquiry. Unfortunately, of course, there is no way for that principle to be put in more detailed form because obviously the precise facts of each case have to be analysed on its own. So for this particular case, the court did find that the complainant, because of the influence of alcohol, had completely lost capacity to consent. And the reason for that is that I suppose the degree of intoxication was much higher than what we see in this case. So unlike this Mr. Tan case where there were acts suggesting ability to make purposeful decisions and take action, in that case we had a situation where the complainant had lost control of even basic motor functions. So for example, the complainant there had tried to push the accused but could only push weakly, and trial judge and the Court of Appeal there found that this was evidence that the victim was not consenting but yet was so intoxicated that she couldn't even push with force. And then there are signs of severe intoxication. So we had the victim vomiting, we had the victim foaming at the mouth, and also there was an issue regarding why the accused answered the victim's handphone. The court said the accused holding on to the victim's handphone could only be explained by the victim was just so intoxicated that she couldn't even hold on to her own handphone. So I suppose the distinction between that case and this case really is over there. Even though the victim had not lapsed completely into unconsciousness, her motor abilities were very much more impaired by alcohol, and she was really no longer capable of articulating her consent, whereas here there were really all the data points that may show to a reasonable person that the complainant was still able to consent.
Okay, so that is really the first limb of the defense, which is, in any rape case, most accused will raise these two limbs of defense. The first is that there was consent, and the second is that there was a mistake of fact, which is that the accused believed, whether mistakenly or otherwise, that consent had been given. So let's talk about the Tan case again. In the Tan case, there was also an issue of mistake of fact where Mr. Tan believed that she had consented. So can we go through some of the factors in this case which led to the judge deciding that there was in fact consent?
There unfortunately isn't much specifically on the issue of this defense of mistake, but from the newspaper it would appear that the judge really relied on all the same factors, the same 6 data points that led to him finding that there was consent. So he's still saying, for example, when the victim was able to refuse her friend's offers to bring her home, or at the end of the whole episode when the complainant was able to tell Mr. Tan, please drive away now. Even if this may have been said while the accused was not in a position to consent, this could still be perceived by a reasonable observer in Mr. Tan's position as somebody manifesting an ability to understand and decide.
So I think the 2016 case is actually more interesting in terms of the mistake, or at least maybe not more interesting, but we have more information because there is a written decision. But in this case, the accused tried to argue a number of things. So he tried to argue that he was entitled to take it that consent was given because the victim was flirting with him and there was sufficient objective and medical evidence of a significant period of foreplay between the victim and the accused, from which one could infer that the victim was a willing and consenting participant to sex. And also that the accused himself was drinking, and that the accused being 23 years old at the time should not be characterized as a predator, but more as a youth who had simply made a misguided decision. Of course, the judge rejected all of these arguments. They said that even if the victim was flirting with the accused, that does not mean that she led him to believe that she would consent to digital or penile penetration. They also rejected the accused version of events that there had been foreplay, and they felt that the small age gap did not really say much either way. Another thing they took into consideration was the fact that he had not attempted to show he had exercised due care and attention in arriving at his belief. So maybe let's talk about this last point, which is exercising due care and attention in arriving at his belief.
Yes, so it will be a strange sort of due diligence, if I may say so. So, and the Court of Appeal did make an observation regarding this legal requirement. This legal requirement of taking due care that your belief must be reasonable and in good faith is adopted from the wording of, I believe, Section 79 of the Penal Code. We had in a previous episode talked about the genesis of the Penal Code. And this was actually quite a clear departure from the legal position in England. In England, so long as the accused proves that he believed, no matter how unreasonable the belief that the person had consented, there will be a defense. But in the Singapore context, it's not sufficient for the accused to show that he believed. He also needs to show that this belief was reasonable after exercising due care. One last point that I found quite interesting regarding this case was that the facts at first glance look quite egregious. In fact, it is made more egregious by the fact that the complainant had been so blacked out by alcohol that she didn't have any memory at all of what happened that night. So in fact, when she got called to the stand to give testimony, all that she was able to say was, I had completely blacked out and I can't tell you anything about what happened. So this was not minor intoxication, this was quite serious intoxication. Despite the fact of complete blacking out, resulting in her not having any memory of the incident at all, the judge still acquitted this accused person.
Sorry, just a quick question. Did the judge make any comments or decision regarding her state of blacking out?
I recall in the article he did speak about expert evidence that was produced in that case, which shows that yes, persons can be under the influence of alcohol such that later on they may have no recollection at all of what happened while they were under the influence of alcohol. But even if so, you could still, when you are under the influence of alcohol, have the ability to understand and to decide. So there was expert evidence in that case, which was, I believe, common position by both prosecution and defense, that yes, even if later on you totally couldn't remember of what you done because of the influence of alcohol, still you could have had the capacity to understand and to decide. So that was interesting. Following on from this, the second interesting point would be that given that she couldn't give any evidence of what had happened, the accused's own testimony becomes all the more crucial. So this is where the judge said, overall, he found that the accused was consistent in his statements given to the police. So what he's saying in court was consistent with what he had told the police while under interrogation. The judge found it significant that when the accused was interrogated, the accused had not yet known that the victim would not have remembered what had happened. So I suppose what the judge was saying is, even when you didn't know that the other side would not be able to remember this, you were still honest in saying things that were incriminating about yourself potentially. That's number one. And number two, I suppose luckily for the accused person, there was objective evidence in the form of, for example, the cam footage, which shows that yes, she was capable of interacting and communicating with the accused while she was in the taxi.
I thought one of the interesting things was when in the in-cam footage, you could hear the accused saying, I can't put it in. And the judge actually commented on that, I can't put it in. He said that this shows that there was some kind of interaction between the two parties that was not purely, I'm forcing myself on you.
Monologue.
Wow.
That's your expectation, right? I can't put it in. Your expectation is that your partner would move so that you could facilitate. And another consideration the judge had was that after all this, she had willingly performed oral sex on him, and there was no force in that action. So that was another consideration that the judge put some weight on.
So I guess very fortunate for this particular accused person that he had backing from objective evidence, which is the footage. Also crucial is what I mentioned earlier in terms of consistencies between his statements, because not to forget, not only did he not know yet that she couldn't remember. In Singapore, generally when you are being interrogated, even for very serious offences, you don't have an immediate right to have legal advice, and you certainly don't have the right to have a lawyer accompany you when you are being interrogated.
That's a whole other conversation to have. Okay, anyway, I think that's about it. Anything else? Nope. If not, then that's goodbye from me.
Bye.
Bye.
Nothing herein shall constitute legal advice nor create a solicitor-client relationship. If you are currently facing legal troubles, please seek your own independent legal advice. Many law firms provide a non-obligatory, free of charge first meeting, especially for divorce and criminal matters. All opinions expressed here are our own and do not reflect the values, opinions, and practices of our firms, friends, and families.